Good day, everyone. For my informative speech, I will be talking about unjustifiable dismissal. We would have touched on this topic for our midterm, where we would have reviewed cases based on unjustifiable dismissal. But for my informative speech, I will try to go a little more in depth where this topic is concerned. So we'll speak about dismissal, which refers to the act of terminating the employment of an employee by the employer in an organization. Dismissal can also be referred to as firing or sacking. Depending on the reason of termination, there are two types of dismissal: fair and unfair dismissal. Fair dismissal refers to dismissal of an employee for a justifiable or lawful reason. These reasons may include, but are not limited to, capability, qualifications, conduct, redundancy, illegality, and other substantial reasons. Unjustifiable, unjust, unfair, or wrongful dismissal are all terms in the labor law to describe an act of employment termination or dismissal of an employee without sound justifiable reasons or contrary to legislative laws of the country in which the company operates. Different countries have diverse laws in this regard, but more or less all laws tend to favor the employee and protect their interests. The obligation of justifying any dismissal generally lies with the employer. Constructive dismissal, which falls under unjustifiable dismissal, is one where an employee is forced to leave a job against their will because of the actions or conduct of the employer. In order to be lawful, a dismissal of an employee must be substantively justified and must be conducted in procedurally fair manner. In order to be substantively justified, there must be a genuine reason for a dismissal. Requirements of procedural fairness may vary depending on the circumstances surrounding the reason. The test of whether the dismissal was justifiable and the procedure was fair is an objective one, namely, whether it meets the standard of what a fair and reasonable employer would have done under the given circumstances. Gross misconduct. If there has been serious or gross misconduct, a summary dismissal will be justified. That is, the employee can be dismissed without receiving any earlier notice or warning. However, the dismissal must still be procedurally fair. Gross misconduct is behavior that makes it immediately and definitively impossible to maintain an employment relationship. Examples of serious gross misconduct include criminal damage to work property, theft and fraud, discrimination. We also have negligence here, possessing illegal drug, possessing of illegal substances, falsifying experience and qualifications, and leaking confidential information, to name a few. A summary or immediate dismissal still requires proper procedure. The employee must receive a letter notifying him or her of the dismissal, which must explicitly detail the misconduct of which the employee is being accused. If this is not the case, the dismissal is unfair. Dismissal with notice. If the grounds for taking action is based on poor work performance or some less serious form of misconduct, the employer cannot dismiss the employee unless there has been previous warnings about the poor performance or the misconduct. The accepted procedure is usually to first give an oral warning, then a formal written warning, suspension, and then, if necessary, dismissal, if no other reasonable and or fair alternative is available. General rules for procedural dismissal. So in order for dismissal to be lawful, you must first launch a full investigation into the alleged behavior. This must be carried out. The employee should be informed about the exact nature of the allegations and, where appropriate, that dismissal is a possible outcome of the disciplinary process. The employee should be given an opportunity to be heard. The employee should be given the option of having a support person or lawyer present when the hearing takes place. Unless the conduct is in question justifies summary or immediate dismissal, the employee must be warned and asked to stop the misconduct or improve the poor performance. Assistance can be given in this area. The employee should be given the reasons for the decision that you eventually reach. It is advisable that these be given before any dismissal. However, the employee has the right within 60 days after the dismissal or after becoming aware of it to request you to provide a written statement of the reasons, and this must be provided to him within 14 days. A dismissal should be notified in writing. An employee can be suspended on full pay pending the outcome of the disciplinary process. The employee must also ensure that any dismissal is carried out in compliance with any specific terms of employment contract. For example, the contract might set out the warning procedure that must be followed or a definition of serious misconduct. Here are my references, and I would just like to add that last week I came across an article where an industrial relations officer was pleading with companies to follow proper procedures, because this ensures that when you follow proper procedures, that when it goes to court, if it does reach there, that they will not be seen as wrong in dismissing the person where procedures are concerned. So thank you, and I hope that this was very helpful where unjustifiable dismissal is concerned.